All right, there's 3 cases on this. Can y'all work on getting these printed, please, on Gerald Jackson? There's 3 of them. I'll do the first one.
Right away, you can tell this courtroom is running on volume. Multiple cases, multiple indictments. And the judge is clearly trying to keep things efficient. This is what real-world plea dockets look like. Fast, procedural, and unforgiving.
Give me just a second. Since there's multiple and I get them printed out, it'll just be easier.
Dealing in volume.
You are. Removing some stuff, that's good. Are y'all both able to get to them, or do you need me to? Okay. We were told the other day that you have been moved to the top of that list when you were gone. I mean, it is. All right, sir, are you Gerald Jackson? And Mr. Zuniga, will your client waive the formal reading of the indictment in each of his cases? Mr. Jackson, in cause number 24 DCCR 0706, you're charged with the state jail felony offense of credit or debit card abuse. And that's from December 13th of 2023. And how do you plead to that charge?
Notice how the judge confirms the plea is freely and voluntarily. That's not just a formality. It's critical. If that step is skipped, the entire plea can be challenged later. This is the court locking the record tight.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? And then in cause number 24 DCCR 0707, you're charged with the state jail felony offense of credit or debit card abuse from December 15th of 2023. And how do you plead to that charge? And again, are you pleading guilty freely and voluntarily? And because you did what they charged you with? And then in that last case, are you going on the priors or just the state jail? In cause number 24 DCCR 1170, you're charged with the state jail felony offense of theft of property from April 1st of 2024. That indictment alleges that you were previously convicted of aggravated robbery, first-degree felony, November 20th of 2013, and that after that was final, you were convicted of evading arrest or detention with the use of a vehicle, September 15th of 2019, and on that same date of September 25th of 2019, also convicted of felon in possession of a firearm. Is that correct?
Here's where things get serious. Prior convictions, especially aggravated robbery, completely change the game. What could have been minor time suddenly turns into years. This is how criminal history follows you into every courtroom.
And how do you plead to that charge? And are those prior convictions true? Did you enter your plea of guilty and true in that case freely and voluntarily, and because you did what they charged you with? In all of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with your attorney? Do you fully understand them? And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal? State tenders number 1 in each case. It's admitted in each case. Is there any evidence that Mr. Jackson is not competent? All right, sir, in all of your cases, I'm going to find that you entered your pleas of guilty and then true in that last case freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. In cause number 24 DCCR 0706 find sufficient evidence to find you guilty, and at this time find you guilty of debit or credit card abuse. Sentence you in accordance with your agreement to a term of 180 days in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 24 DCCR 0707, find sufficient evidence to find you guilty, and at this time find you guilty of credit debit card abuse. Sentence you in accordance with that agreement to a term of 180 days in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 24 DCCR 1170, find sufficient evidence to find you guilty, and at this time find you guilty and find those prior convictions true. Sentence you in accordance with your agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will all run concurrently, which means together at the same time.
This is actually a huge break for the defendant. Concurrent means all sentences run at the same time, not stacked. Without that agreement, we'd be talking about far more than 6 years. Would you have taken this deal?
I'm going to hand you in each of your cases the trial court certification that shows that these were agreements that I followed, so you waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered, or the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. I know you already know this because of that prior, but I'm required now to read it. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can speak with your attorney. All right, good luck to you, sir. You can go back with the bailiff. Thank you. Thank you. Yes, sir. Thank you so much. Have a good day. Good morning, sir. You're Forrest Mabry. And Ms. Holmes, will your client waive the formal reading of the indictment in each case?
Yes, sir.
Give me just a second. Mr. Mabry, in cause number 25, DCCR 0580, let's see, are we going on? Okay. More
On
than
the first, I think
We can do paragraphs 1 and 3, Your Honor.
1 and 3. The state is proceeding on paragraphs 1 and 3. Count 1 alleges that you committed the third-degree felony offense of stalking on April 7th of 2025. That indictment alleges that you were previously convicted of, gosh, I can't read this. It's,
Improper use.
the felony, third-degree felony offense of improper use of equipment from September 27th of 2007. And how do you plead to that charge? And is that prior conviction true? And did you enter your plea of guilty and true, freely and voluntarily? Give me just a second. Why some of the indictments on things to get scanned in look so crazy.
Do you need that here?
Mm.
Do you want to use
No, it's fine. I can print them out and they look fine. I was able to get it done. Let's see. All right, sir. In cause number 25, DCCR 1069, you're charged with the state jail felony offense of credit debit card abuse, and that's from March 26th of 2025. And then in this case, what are we going on?
The indictment is count 1 and then 2 and 3.
2 and 3. Count 2 alleges that you were previously convicted of improper use of equipment, a third-degree felony, September 27th of 2007. After that was final, you were convicted of possession of methamphetamine in a drug-free zone, a second-degree felony, December 18th of 2009. And how do you plead to that charge? And are those prior convictions true? Did you enter your plea of guilty in that case also, and true, freely and voluntarily, and because you did what they charged you with? In each of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case. It's admitted. Is there any evidence that Mr. Mabry is not competent? All right, Mr. Mabry, in each of your cases, I'm going to find that you entered your pleas of guilty and true, freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your pleas. In cause number 25 DCCR 0580, find sufficient evidence to find you guilty, and at this time find you guilty of stalking. Find the prior conviction true. Sentence you in accordance with your agreement to a term of 14 years in the
14 years. Let that sink in. Stalking charges paired with prior felonies are treated extremely seriously in Texas. This isn't about one mistake. It's about a pattern, and the court is making that clear.
Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 25 DCCR 1069, also find that you entered your plea of guilty and true, freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty. Find those prior convictions true. Sentence you in accordance with your agreement to a term of 14 years in the Institutional Division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, good luck to you, sir. You can go back with the bailiff. Oh, there it is. Sorry, that was... All right, you are Otis Crawford Wilson. And will your client waive the formal reading of the motion?
Yes, sir.
Excuse me, Mr. Crawford Wilson, in clause number 20-34521, I have a motion to revoke your community supervision. Shows that you were placed on probation October 21st of 2020 for the third-degree felony offense of escape while arrested or confined, and that was a 10-year term in prison that was probated for 6 years. Is that correct? This motion alleges that you violated your probation. Count 1 alleges that you failed to provide verification of performing the community services directed. Is that true or not true? True or not true? Thank you. Count 2 alleges that you failed to pay your court-assessed fees as directed. As of September 22nd, 2025, you were $3,550 behind. And is that true or not true? And then count 3 alleges that you failed to enter and successfully complete the JCDI program as required. And is that true or not true? Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the tablets documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? State tenders number 1. It's admitted. Is there any evidence that Mr. Crawford Wilson is not competent? All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 4 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows that this was an agreement that I followed, so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right. Good luck to you, sir. You can go back with the bailiff. Well, this is going extra slow. Good morning. Are you Denzel Garner? And Mr. Rojas, will your client waive the formal reading of the motion?
You will.
It's coming. This is ridiculous. Here we go. Okay. Mr. Garner, in cause number 21-36211, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation August 1st, 2022 for the state jail felony offense of possession of a controlled substance. And that was a 4-year deferred probation. Is that correct? And then count 1 alleges that you failed to report as directed to the probation department March, April, and May of 2025. And is that true or not true? True or not true? Thank you. Count 2 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true? And then count 3 alleges that you are behind in your court-assessed fees as of June 6th of 2025 in the amount of $4,009. Is that true or not true? Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you sign these, did you go over them with Mr. Rojas? Do you fully understand? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for me to continue your probation, but extend it for 2 years. Is that your understanding? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Garner is not competent?
There you are.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation. But it sounds like everybody's willing to work with you, so I'm going to follow this agreement, continue you on probation, extend your probation for 2 years. You're obviously ordered to still follow all of the rules and conditions of probation, which is very important, because what happens after today is if you don't do it and you're back here again on another motion to revoke your probation for any reason, things will probably not go this way.
This might be the most important moment in the entire video. The judge is basically saying, this is your last lifeline. One more violation, and state jail is almost guaranteed. How many chances should the system give?
Chance to take advantage of it, so that you can finish out this probation and not have the conviction. Because if you don't, you could go to state jail for up to 2 years. All right, I'm handing you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. All right, good luck to you, sir.